It's a more, and we're going to do most of our time singing oldies.
Yeah, that's
You must remember.
All right, everyone, we're going to get started now.
Oh,
Sorry, Professor Epstein. My name is Aaron Jacobowitz, and I'm a programming director with the University of Chicago Law School's chapter of the Federalist Society. I have the pleasure of introducing our panel today, but before I do so, I just wanted to say a big thank you to the First Liberty Institute's Center for Religion, Culture, and Democracy, and the James Wilson Institute for putting together this event. We're all incredibly excited for it. The panel today is filled with people who are at the top of the legal field. All of them have written numerous books and scholarly articles, and so I'll keep my introductions brief. Moderating will be Professor Adam MacLeod. Professor MacLeod is a professor of law and the Catherine A. Ryan Chair for Global and International Law at St. Mary's University School of Law. He's also a senior research fellow with the Center for Religion, Culture, and Democracy. He obtained his bachelor's degree and law degree, he obtained his bachelor's degree from Gordon College and law degree from Notre Dame. After law school, Professor MacLeod clerked on the Massachusetts Appeals Court for Chief Justice Christian Armstrong and Justice Benjamin Kaplan. He then clerked on the District Court for the District of Colorado for Chief Judge Louis T. Babcock. Before moving to academia, Professor MacLeod served as a Special Deputy Attorney General for the state of Alabama. Our first panelist will be Professor Richard A. Epstein. Professor Richard Epstein is the Lawrence A. Tisch Professor of Law at New York University and the James Parker Hall Distinguished Service Professor Emeritus and Senior Lecturer in Law here at the University of Chicago Law School. He's also the founder and director of the Classical Liberal Institute at New York University School of Law. He obtained bachelor's degrees from Columbia and Oxford and an LLB from Yale. Next, we'll hear from Professor Andrew Koppelman. Professor Koppelman is the John Paul Stevens Professor of Law at Northwestern Law School. He obtained his bachelor's degree just north of the Midway at the University of Chicago, and then an MA, JD, and PhD from Yale. After law school, Professor Koppelman clerked on the Connecticut Supreme Court for Chief Justice Ellen A. Peters.
Did you really?
Before moving into academia, Professor Koppelman served as a staff member on the Senate's Commerce Committee. Finally, we'll hear from Professor Gerard Bradley. Professor Bradley is a professor of law at Notre Dame, where he co-directs the Natural Law Institute. He also serves as co-director and senior fellow for the James Wilson Institute and co-editor of the American Journal of Jurisprudence. Before moving into academia, Professor Bradley served in the trial division of the Manhattan District Attorney's Office. Please join me in welcoming our speakers.
Well, thank you very much, Aaron. Thank you also to Colin Mitchell, who's around here. There he is. He's over here. To the University of Chicago and the Federalist Society chapter for hosting us. And for all of you for showing up on helping to make this room very crowded, which is exciting. And hopefully, well, I'm very confident that the panelists will deliver the goods. Also would like just to mention the James Wilson Institute on Natural Rights and the American Founding, one of our co-sponsors, has a summer fellowship program, which is, I think, accepting applications. Garrett Snedeker over here is the guy to see for that. First Liberty Institute, which is the parent organization of the Center for Religion, Culture, and Democracy, our other co-sponsor, has a summer internship program, which Aaron Smith, sitting over here, if any of you are interested in either of those programs. We've got folks in the room who will make the pitch to you. This is a Federalist Society event, so we have to begin with the Federalist Papers, right? Federalist 78, Alexander Hamilton assured his fellow Americans that they had no reason to fear the federal judiciary. The judiciary, he reasoned, from the nature of its functions, will always be the least dangerous to the political rights of the Constitution, lacking the sword of the community, which of course is entrusted to the executive, and the purse, which belongs to the legislative branch, the Supreme Court of the United States, and any inferior tribunals which Congress might create, may truly be said to have neither force nor will, but merely judgment. Times changed. At various moments since the American founding, Americans have had occasion to doubt nearly every aspect of Hamilton's assurance, from the least dangerous to even the merely. Nevertheless, at what may be considered the nadir of judicial integrity in American history, after the Supreme Court's infamous decision in Dred Scott versus Sanford, Abraham Lincoln assured the nation that though he would exercise his independent power to interpret and enforce the Constitution, he would exercise and respect and obey the court's judgment. Even as he exposed the manifest errors in Chief Justice Taney's opinion for the court, he insisted that the court's judgments must be binding in any case upon the parties to a suit as to the object of that suit, while they're also entitled to very high respect and consideration in all parallel cases by all other departments of the government. The 20th century, of course, witnessed challenges to the independence of the federal judiciary, most notably FDR's abandoned court packing plan, and to the constitutional authority of federal courts over state officials, as some attempted to resist judicially mandated integration. But now times have changed again. The buzzword of the day with respect to the Supreme Court is legitimacy. Now, both Presidents Biden and Trump have had sharp words for the court in recent years, but neither has openly defied its judgments.
Yeah.
But other influential American jurists and opinion shapers worry. So recently, Northwestern University law professor John McGinnis lamented, journalists and professors have formed a ululating chorus mourning the loss of the Supreme Court's legitimacy. For example, UC Berkeley law dean Erwin Chemerinsky has espied a cloud over the court's legitimacy, which he attributed to the bitter fight over the confirmation of Brett Kavanaugh. Around the same time, Yale law professor Bruce Ackerman predicted that unless Congress reforms the judiciary, there will be no stopping the escalating political partisanship that will predictably destroy the court's legitimacy in the coming decade. United States senators, members of Congress, and other public officials have added their voices to the chorus. After Justice Kavanaugh's confirmation, for example, then U.S. Attorney General Eric Holder tweeted, "The legitimacy of the Supreme Court can justifiably be questioned. The court must now prove through its work that it is worthy of the nation's trust." Since the court overturned Roe v. Wade in its 2022 decision in Dobbs v. Jackson Women's Health Organization, political scientists who are interested in measuring the court's legitimacy have begun sounding alarm bells. They've published their findings under titles such as, quote, "Losing Legitimacy, the Challenge of the Dobbs Ruling," and "Partisan Sorting, Fatalism, and Supreme Court Legitimacy." Their most concrete and unsettling finding seems to be that an increasing number of Americans who disapprove of the court's so-called outputs view disobedience of the court's judgments as justified. So the question we take up this evening is not only important, but I think urgent. As you've just heard, we're guided by three very able legal scholars. All three of them have published important books and landmark law review articles, not only elucidating the nature of law generally, but the Supreme Court's jurisprudence specifically. We're going to hear from Professor Epstein first, then Professor Koppelman, then Professor Bradley, and then we will have time for questions at the end.
Yeah. Well, thank you very much for that glorious introduction. I just wanted to say that he clerked for Ellen Peters. I used to hang around with Ellen Peters when I was a student at Yale, and we called her class Darkness at Noon, because that was the time it was taught, and none of us understood secure transactions. I'm going to talk not about secure transactions today, but about insecure relationships that seem to exist with the political sphere. Adam reminded me of all the bad stuff that had happened before Trump got into office, and much of it was mischief from the left as opposed to from the right. And I think if I had ample time, I would do this. But I basically treated this as an exercise to try to talk about what I think is one of the most important issues that we have to deal with, where there were excesses on the part of the Biden administration, which I sued at one time because I thought, and correctly, that he had dumped people out of advisory boards without constitutional authority. And I could assure you that I was a successful lawyer and that I could not even establish standing for my clients who were bounced out of these arrangements. So when I start to go after the Trump administration, which I will, I don't want anybody to think that it's an endorsement of anything that happened before. The low ranking of the United States Supreme Court in the eyes of many people, it's a double blow. The polarization is very, very clear on both sides, and it turns out that there are a lot of rulings both ways that are very difficult. But what I'm going to do is actually not talk about this in the abstract sense. I'm going to talk about an issue which has been part of our nation since the founding of the Republic, and it has to do with the scope of executive power. And one of the things to understand about this is you're a good constitutional lawyer. You don't start with the Constitution. You start with the law of contract. And the first thing you do when you start with the law of contract is to try to figure out whether or not there's some huge gaps in the original doctrine for which you're going to have to imply something to fill them in. And sure enough, at the first situation, we had the debate over legitimacy in 1789 on the very simple question of who is it that gets to remove somebody from office. The Constitution makes it very clear what the process for selection is in one of its most murky clauses, basically the appointments clause, where some appointments are direct, some are not direct, some are optional one way or another, but nothing is said about how you start to deal with the question of removal. So if you're a textualist, your day is over because there's nothing you can say about something that is not written. If you're a serious contractual lawyer, what you understand is that every civil contract is done against the sort of background of normative propositions that are usually inarticulate that you have to explain, and that basically a text that's like this, which purports to be complete, is like lots of things in ordinary English, where you know exactly what's going on because the background context is sufficiently strong and you can do it. So if you were to start thinking about how you fill in terms in contract, the fundamental principle that one tries to apply is a principle of good faith in incomplete agreements. That doesn't mean you could do whatever you want. It's just if you look at a particular text which seems to be wildly imbalanced so that one party is favored and the other is not, you imply counter terms of good faith obligation in order to make sure that it meets what you want contracts to do, which is the prospect of mutual gain from the ex ante process. And if you look at corporate law and so forth, you have exactly the same kinds of issues that are faced when you're trying to figure out, do you impose a strict scrutiny or a business judgment rule? And it's exactly these techniques, particularly the latter, that start to come very much important in this case. So now when you start looking at this, what you do is you find the following very sensible principle in the early situation, which is if you're dealing with senior officials in whom the president has to place trust, those people whom he has to hire with Senate confirmation, he may fire at will, where the check on that is if he has to put somebody else into office, he's going to have to go through the confirmation situation. So it's going to be a power which he will exercise sparingly, but will be his. Whereas when you start talking about people who are inferior offices, you don't need to put that particular presumption in favor. And so if you start looking at the Constitution, the debates over 1789 do not deal with the sufficient people. We then run a vast expansion of the American government, form a civil service union, and then we get a guy named William Howard Taft, who served as president, now comes on the Supreme Court in a case called Myers. And what he has to do is to figure out whether or not the president can fire at will a postmaster third class from Oregon who has no such powers. And frankly, he blew it. The correct way to think about this is the people whom you can fire are those who are good advisors, and maybe the postmaster guy we're talking about is, but the betting odds is not. And so if he had been appointed by an inferior officer, would have been perfectly loyal, then he could only be dismissed under the Civil Service Act, which makes it very clear that a theory of the unitary executive, which claims that anybody who's in the executive branch of government is subject to dismissal at the will of the president, was in fact not practiced at that time. And what happened is Taft took the general proposition seriously, but then missed it in the particular case. Why did you put this guy nominated this way? But it seems pretty clear to me that if you are validly appointed, you don't want one set of rules on dismissal if you're appointed with a Senate confirmation and the other not. And so what happened is the dissenters all started to say, when you're dealing with various kinds of inferior offices, that particular power does not exist. So when you then start looking a little bit further forward on this, it turns out, how does this thing get played out afterwards? The single most important case that you have to worry about on this is Justice Black and the situation that we had with respect to the steel seizure cases. And there are two features about Justice Black that you have to know. One is that he was a simpleton, and two, he was correct. And the latter is, in fact, directly response to the first one. What is the great curse of modern American law is we spend all our time on wind-up and no time on actually reading text to figure out what they mean. And so we have presumptions of deference, presumptions of oversight, one sort or another, big questions, little questions, rules, and so forth. And Justice Black was a simpleton, so he said, I'll look at this document. I see that the president's supposed to be commander-in-chief. I don't think a commander-in-chief is allowed to close the mind. And when I looked at what Congress said, because they're involved in this, they did not give the president that power when they worked on the Labor Reform Acts of 1947, 1946. And for those of you who are too young to remember this, the Labor Reform Acts in 1946 was one of the 2 or 3 major items on the domestic agenda. And so when the Congress passed the Taft-Hartley Act and the Management Act, when it said something, he said it counted. So then he starts looking at the statutes. He says, I don't see any express authorization. Given that, I don't see any implied authorization. President loses, end of day. And so what you're doing here is you're getting a guy who has a very nuanced view of what the executive is. And then if you actually look at the clauses that he's trying to import, it turns out having a good eye for the private law subjects gives you an idea that this kind of a mixed regime is what he wants. And so just to say this, we have one president. Well, that's a really powerful indication because it means you don't have 2 presidents, but it doesn't mean the one president that you have has completely unlimited powers, as the people who believe in the unitary executive in the modern version say. And so what you have to do is to read the rest of it and to take care that the laws be faithfully executed. Now, since we're all very careful textualists at this point, and we actually do have a text, the first word you want to look at is the word be, and it means that he's not doing everything. There are obviously going to be other people who are going to have some kinds of power, and there will be laws that are going to be enforced, and they have to be faithfully executed, which is the standard notion for fiduciary duties that comes out of medieval law. Me and Helmholtz always talk about that in our lunchtime. And those are duties of loyalty on the one hand and duties of care on the other, to respect the congressional law that goes into place. And so there's no way that you can read those laws as to say the president can do whatever he wants. In fact, what you do is his job is to make sure that whatever Congress decreed to be done within its powers, he does within his job. And so the entire system of a unitary executive who can disregard everything and anything that is going to be stated is, in fact, in the early cases, a myth. If you then go back and look at the cases somewhat before it, and you take a case called Perkins from 1886, what happens is the statute was very clear. Congress said these are military guys, and this is the only way in which they can be discharged, and the president, therefore, must be bound by it. And that case is extremely important because it reinforces the same view that you had everywhere else. When you then come to all the cases that came out of the Gulf Wars, Hamden and Hamdi, it was exactly the same stuff. They said, yeah, you can go after these people with novel tribunals, but the president doesn't have the power to abridge the due process rights of any individual who comes into the country. And for those of you who forget it, the Constitution uses citizenship for privileges and immunities, but persons with respect to due process and equal protection. And persons include enemies, and enemies include enemy aliens of one kind or another. And so Justice O'Connor rightly insisted that you follow these kinds of procedures. When we come further forward, however, it turns out we see the president time after time simply asserting, well, I'm in charge of this particular shop, and whatever I want to do, I can do, whether it's removing people from the country, whether it's canceling grants of one kind or another. And it is in direct violation of what the system is. So that's the first point that one wants to make, is the idea that there is some kind of specific authorization for the kinds of activities that have taken place is utterly inconsistent with the kind of mixed regime that was put into place, and which is justified, I think, by a close reading of the text. Now, there's another problem that you alluded to, and you anticipated my speech without knowing it, for which I don't forgive you. You said the United States is not the same place that it was in 1787. That is something I was never aware of. We're basically 100 times larger. We got 50 states. We have administrative agencies and so forth. We have a Commerce Clause which was utterly unrecognizable from the Commerce Clause that we had back in even as late as 1824 and so forth. And things are changing. And one of the things that you always discover when things start to change is that the square cube law starts to apply to expansion of any situation. And what it means, in effect, is if you want to square the output that you have, what you have to do is to cube the support system that you have, which is why you cannot carry relative to your weight as much as an ant can, because you have to cube everything at the bottom and you square things at the top, and you can see what the diminution is. Well, that's true of government. And you want to expand the functions that you do, you have to cube the infrastructure that you're going to put into place in order to be able to do it. And what does this do? Well, it leads to the adoption at the federal level of a system which had made its way first at the state level. The notion of a commission as being a body that actually decides anything is a relatively late development, and it started first with the railroad commissions in the states, and then with the workmen's compensation systems that came a generation later. And it turns out these things are not perfect, but they seem to do better, because courts were not very good at setting the rates on 10,000 given commodities that were going to go from one end of Minnesota to the other. And you get all sorts of worker injury cases that would clog the courts given industrialization. So everybody did it. The great question was then, how do you transfer this into the federal system where there's no explicit authorization for these courts at all? And well, you do the only thing you can do when you're faced with a necessity: you cheat. And what does that mean? Well, the first of these cases was Crowell and Benson, and Justice Hughes was one of the craftiest guys who ever lived, and he found a way to allow a workman's compensation system to work and decide routine cases by having appellate jurisdiction over questions of law and having them also with respect to whether or not you're covering a case that falls within the statute. It wasn't quite right. And then you get to Humphrey's executor. And it turns out this opinion is widely derided because it uses two phrases that are clearly inappropriate. It calls this a quasi-legislative and a quasi-judicial. And quasi in this context means crazy. And so what all people want to say is there's no such thing as crazy. It's A, B, or C, animal, vegetable, or mineral. But it turns out if you read the rest of the opinion that Sutherland wrote, he was not a fool. He says, I'm looking at these commissions, and I'm looking at Myers, and the guy who's Secretary of State is not the same as a guy who's trying to figure out on the FTC or the ICC, any of these commissions, what kind of technical provision you're putting into place. So he said the key thing that we want is independence. And he was absolutely right. You can't run one of these things unless you do it. So that's why I use the other words. And we get the independent agency. Now, are these things justified by an originalist form of the Constitution? The answer is no. I've read a dozen articles where people have a genius scheme saying it works, and they're all palpably laughable. So what is it that's going on? Well, it turns out you got to go back to the private law from Rome, Jus Capio, and the adverse possession body of law. And what both these bodies of law say is if you do something wrong long enough, it becomes right. And the question, so everybody said, ha, ha, ha. But the issue is there any system which has ever denied that proposition in its day-to-day operation? And the answer is no. Statutes of limitation, novel decease, and Jus Capio, and so forth, were much a part of the system. And that's what's exactly happened in the Constitution. By the time they put the Interstate Commerce Act into place in 1886, nobody wanted to challenge it. And so you go through the Hepburn Act and so forth. And by the time it's 50 years old, somebody said, well, let's undo it. And then, well, what about all those decisions that have taken place, all those rates that have taken place? Do we undo that too? And somebody said, no. And so they said, we're doing it by essentially, we've done it long enough, we're not going to change it because it's met the test of time. It's not Richard Epstein who thinks it's a good idea. It's everybody who worked in the particular system. And so it keeps going for 80 years until the originalists come back and they say reliance, interest, and transformations are not part of the original Constitution, and they aren't. And then they say it's just the mere subjective preferences of idlers like myself, and it's not that either. It turns out that there's a very good set of functional explanations, and the Supreme Court, well, they don't handle this correctly. They say, well, with the Federal Reserve, it's obvious that we need independence. Oh, but we'll strike down all the other independent agencies. And like, why? Do we really not want independence when it comes to the election board? Do we want the labor board to be stacked with presidential appointments from one party or another? The whole thing turns out to be a horror. And so what happens is, the way in which you have to do this is to take the point that you made very seriously, that changes in circumstances lead to changes in constitutional structure. And if you don't do that, Well, let me tell you what's going to happen to Mr. Trump. None of you have heard of an institution called ICE having to do with immigration. Look at the original Constitution. Tell me where the federal government has a jurisdiction over immigration. The answer is it does not. So we now have to dismantle that operation, which was put into place in 1889 with the Chinese exclusion cases, with the following deep argument. Everybody knows that immigration is a power incident to running a government. It was indeed for state governments under the original Constitution. Now it gets transformed, and by 1941, it becomes not only transformed, but it's supreme, and the states are completely dismoved from it. It's all judicial stuff. Well, the question is, when you want to play the originalist game, do you always want to do it with the clauses? I'm going to end on this note, that with the clauses that you like or don't like, but with the ones you do like. And let me tell you what's illegitimate under the originalist interpretation. I could do that. Well, one case that obviously goes is Marbury v. Madison, because as Lincoln said, the Supreme Court has absolute control over the cases it could take, but it has no power to bind other institutions. And that's the way the thing was drafted. And it was Justice Marshall and Justice Story, two renegades, who essentially flipped both those things around. So it was no longer the state courts that had the primary responsibility to interpret the federal composition, and you couldn't block appeals to the Supreme Court, except in limited cases, which now nobody wants to exercise. Well, are corporations citizens? Of course, that's not particularly the case. What about the doctrine of unconstitutional condition? Well, that doesn't exist anywhere. And there's something called the police power. And the last I looked at the Constitution, it wasn't there either. So what you have to do is the point that I started out with. When you're taking a doctrine that looks like it's complete, but you know darn well that it's not, you have to have some kind of tradition to figure out how you fill it in. And I start with two places. They're both Roman, but they're both current. I'm a Roman law professor at heart. And the first of those is the whole rules about the apparatus of interpretation, which are much more flexible than modern originalists do. And if you take something like the Lex Aquilia, you take the word injuria, and you have to spend 30 pages figuring out what it means. And you can do it if you know what you're doing. And then there's also the prescription stuff. And that also starts in Roman and early English law. So all of you have studied and broken your chops, as I don't do today anymore, on usucapium on the one hand and novel decision on the other hand, will find this very comfortable as the way in which the system starts to work. And so what you really need to do is to understand the present, you have to understand the past. And so the problem I'm seeing in a room like this is most of you who are very young are given a constitutional tradition that starts somewhere around 1985 and 1990. And what happens is you got to go back a couple of thousand years in order to brush up on your earlier stuff, because otherwise you'll never get the modern stuff right. And the consequence is Donald Trump's exaggerated theories of the unitary executive. I don't have time to go into it now, but which have been appallingly accepted in cases like the oil states case and so forth, and Arthrex and the patent courts. Total disgrace, but I'll save them for later, because if my time isn't up, I'm going to pretend that it is anyhow.
Thank you, Richard. Very good.
All right, done.
All right. So, unlike Richard, I'm going to work with notes. Everybody's thinking it. Might as well say it. I'm not as smart as Richard. But the question where I've been asked to respond to is the Supreme Court legitimate? And so that put me in mind of a quotation that I've always loved, which I was heartbroken to discover on investigation, that Mohandas Gandhi did not, in fact, say. The story goes that Mohandas Gandhi was once asked, "What do you think of Western civilization?" And he is supposed to have responded, "I think it would be a good idea." Now, he died in 1948, but the first appearance of the quotation is 1967, so it doesn't seem to have been him. Nonetheless, I'm titling my paper, "A Legitimate Supreme Court Would Be a Good Idea." So the question I take it we're responding to, at least the question I'm going to try to answer, is should the Supreme Court care what the public thinks of its decisions? And is it appropriate for members of the public who are not party to cases to try to influence or even pressure the court? Is it appropriate for Congress to do that? When Biden was president, he proposed term limits and an enforceable code of ethics. Those proposals will be back if we hold another election and if the Democrats win it. So it's a live issue. I'm going to argue that political checks on the court are a good idea because the court has been behaving badly. It is important for the court to be legitimate. But in our present situation, in order for the court to be legitimate in the long run, we have to question its legitimacy today. We shouldn't pretend that we don't notice the court's partisanship and slipshod legal arguments. And so its judges need to be called back to their best selves. They need to earn what we need them to have. And this is particularly urgent in the age of Donald Trump when the rule of law itself is at risk. So I'm going to start by introducing some terminology. Legitimacy means different things in different contexts. And I'm drawing some distinctions from a good book by Richard Fallon here. Legal legitimacy is achieved if the court decides cases by faithfully using the interpretive methods that are generally accepted in the legal culture. That's legal legitimacy. Sociological legitimacy is achieved if the public regards the court's decisions as deserving obedience and respect. And moral legitimacy concerns whether those decisions really do deserve obedience and respect, regardless of what anyone thinks of the soundness of the legal reasoning. And so the question I just asked could be rephrased in these terms. Is it appropriate for the court, when deciding cases, to be influenced by concerns about sociological legitimacy? And is it morally legitimate for the rest of us to try to diminish the court's sociological legitimacy in an effort to influence its decisions? Well, some people think that sociological legitimacy has nothing to do with the law. The court should simply deduce results from the legal sources, and the rest of us should acknowledge that the court has the authority to do that. In Dobbs versus Jackson Women's Health Organization, in which it extinguished the right to abortion, the court said, "We don't pretend to know how our political system or society will respond to today's decision, and even if we could foresee what will happen, we would have no authority to let that knowledge influence our decision. We can only do our job." As for the duty to accept what the court has done, Biden's term limits proposal was denounced. The Wall Street Journal called it an assault on America's basic constitutional structure. Senator Mitch McConnell called it a direct attack on a core institution of our democracy. Mike Johnson, the House Speaker, said that it would tilt the balance of power and erode not only the rule of law, but American people's faith in our system of justice. But does the rule of law really mean that we have an obligation to blindly acquiesce in anything the court tells us? That is a view that's been put forth. It has been claimed, for example, that Americans' belief in themselves as a people who live according to the rule of law is not readily separable from their understanding of the court invested with the authority to decide their constitutional cases and speak before others for their constitutional ideals. And sometimes the Constitution calls the contending sides of a national controversy to end their national division by accepting a common mandate rooted in the Constitution. But these quotes come from Planned Parenthood versus Casey, the 1992 decision that insisted that the abortion decision was settled. We all know how that went. Justice Scalia, I think, was right that those formulations manifest almost czarist arrogance. Legal legitimacy depends on sociological legitimacy. H.L.A. Hart noted long ago that in order for a legal system to exist, officials must embrace shared norms and citizens have to acquiesce in those norms. They have to treat the law as a reason and justification for action. Well, one possible response is to say that sociological legitimacy has to be taken as axiomatic. We've got an obligation to accept anything the court says, otherwise we are jeopardizing the rule of law. But it is possible, there are possible worlds in which the Supreme Court generates decisions that are unworthy of obedience. And when that happens, it has to be permissible at a minimum to agitate for their reversal. That was Abraham Lincoln's view. Abuse of power exists, and citizens have to be able to detect it and call it out. Well, the court's sociological legitimacy is now in question because of the court's partisan polarization. Since 2010, when Justice Kagan replaced Justice Stevens, all of the Supreme Court's Republican-nominated justices have been to the right of Democratic-nominated justices. And this is a new phenomenon in the United States. Before then, the court never had clear ideological blocks that coincided with party lines. And this creates a danger for the court. The number of Americans who think the court's decisions are politically based is at an all-time high, and the divide has a partisan gap. Far more Democrats than Republicans have an unfavorable view of the court. Now, there's nothing new about the claim that judges are making stuff up. In American politics, those complaints repeatedly and predictably arise whenever one party has the power to shape the judiciary. It happens again and again. But it's an open question whether the complaints are justified in any particular case. Well, after the unseemly gamesmanship that led to the appointments of Neil Gorsuch and Amy Coney Barrett, I think that the conservative majority had an obligation to look for opportunities to, as Barrett said shortly after her confirmation, convince you that this court is not comprised of a bunch of partisan hacks. I don't think that the court has risen to this occasion. The starkest betrayal of legal legitimacy involves the abuse of procedure. I'm not going to talk about Dobbs, by the way, because there are matters about which reasonable lawyers can disagree, and abortion is par excellence one of those decisions. So I'm just not going to get into that. But the starkest betrayal of legal legitimacy involves the abuse of procedure. Lawyers sometimes, law students, you need to be ready for this. Lawyers sometimes irritate other people with their pernickettiness about technicalities. But scrupulous about legal detail is what gives courts their authority. And the turn to process in particular, Kunal Parker has a good book on this, because we were divided increasingly about fundamentals, procedure became more important. But the court has been abusing procedural maneuvers in a starkly partisan pattern, and that abuse is clearest in the use of the emergency injunction, which is now popularly known as the shadow docket. The court has the power to issue emergency injunctions where the courts have refused to do so. It's always had that power. It used to use the power sparingly. In recent years, it's issued in an unprecedented volume of unexplained emergency orders that systematically favor Republican office holders and constituencies. It was broadly deferential to presidential power during the first administration. That abruptly ended as soon as Biden was inaugurated, and it sprang back into life as soon as Trump returned. Sometimes the court reversed lower court injunctions that had correctly, as it later turned out, blocked illegal government action. The military ban on transgender members, rule punishing immigrants who needed publicly funded medical care, new limits on asylum for refugees, over and over, policies that no court ever upheld that multiple lower court judges had held to be unlawful were allowed to remain in effect for years because of one-sentence orders from the court. And some of those actions that were put back into place would eventually be deemed unlawful by every court that actually ruled on their merits. And that explosion of emergency orders has happened again in Biden, the emergency orders blocked presidential power. Under Trump, Trump has brought appeals under the emergency order, under the emergency docket, for decisions in which district courts had held his actions unconstitutional. Of 25 such appeals ruled by the justices since January 20th, the administration has won 21 and has short-term victories on bids to cancel federal grants, fire federal workers, boost appointments from independent agencies, and ship undocumented immigrants to countries they have no ties to. The partisan split is a lot clearer at the Supreme Court level than in the lower courts. Trump's challengers in his second administration have a 60% win rate in the nearly 240 orders issued by federal district courts, and there's not that much of a partisan divide. Republican-appointed district judges rule against him 55% of the time, Democrats at 63%. Not that stark. In the Supreme Court, he wins 90% of the time, almost always on the shadow docket with little or no reasoning. And the court has repeatedly scolded lower courts for failing to anticipate that the court would discard longstanding rules. The federal judiciary is understandably concerned. The court has scolded lower courts for defying the court's decision, but when the decisions that supposedly are defied are unaccompanied by any opinion, and different judges, including courts of appeals and some members of the Supreme Court, disagree about how to interpret them, it's not clear how a lower court is supposed to follow them. And so the lower courts judges have grumbled about this anonymously to the press. One federal judge who received threats of violence told the press, "They don't have our backs." Whatever one thinks about the appropriate procedure, unexplained orders that have a partisan spin don't help with the court's sociological legitimacy, and I'll suggest this is because they manifestly lack legal legitimacy. Mindful of my time, I'm going to say less about substantive law. There's a lot of problems with substantive law. I think that I'm just going to talk about two substantive decisions. One is on Nome versus Vasquez-Perdomo, where the district court found that federal immigration officials were stopping and interrogating people, quoting here, based solely on 4 factors: their apparent race or ethnicity, whether they spoke Spanish or English with an accent, the type of location in which they were found, such as a car wash or a bus stop, and the type of job they appeared to work. And the precise and only question before the court was whether those 4 factors alone could trigger reasonable suspicion, or whether an injunction prohibiting detaining people on that ground alone was invalid. Evidently, the answer was that they could, because the injunction against that precise behavior was lifted, as usual, without explanation. And the consequence, Justice Sotomayor, I think, was right. Anyone who looks Latino, speaks Spanish, and appears to work a low-wage job dare not go out onto the street without carrying proof of citizenship. Justice Kavanaugh, who was the only justice who wrote in defense of the order, declared that if anyone is mistakenly stopped, the questioning in those circumstances is typically brief, and those individuals may promptly go free after making clear to the immigration officials that they are U.S. citizens or otherwise legally in the United States. Since then, however, we've got about 170 episodes in which Americans have been dragged, tackled, beaten, tased, shot by immigration agents, had their necks kneeled on. I won't go on with the details. These stops are now known as Kavanaugh stops. This, I'll suggest, is outside the bounds of legal legitimacy. Now, what was wrong with the district court opinion that issued this injunction? We don't know. We only have Justice Kavanaugh's separate opinion. The other substantive decision that I will focus on is Trump versus United States, which held that the president is entitled to use the powers of his office to commit crimes, and as long as he is using his official capacity to do that, he is immune from prosecution. This during the campaign for re-election of a former president who had already attempted to overthrow the government. Now, the Constitution says that if a president is impeached for treason, bribery, or other high crimes and misdemeanors, the party convicted shall nonetheless be liable and subject to indictment, trial, judgment, and punishment according to law. Well, anything an official is impeached for is likely to involve some abuse of official powers. That kind of abuse is, in fact, what bribery is. You cannot bribe an official unless the official somehow misuses his official powers. And so the court here seems to have openly defied the language of the Constitution in order to retroactively authorize criminal activity by a Republican office holder. And so, unsurprisingly, the second Trump administration is an orgy of bribery. It's the most corrupt administration in American history. I won't hide my substantive unhappiness with some of the other... You'll get your turn, Richard.
Unfortunately, I agree with much of what you said.
That's really unfortunate. There's supposed to be a debate here. I don't think the judges were abusing their powers when they overruled Roe versus Wade. There are respectable legal arguments on both sides, but I don't think that's true of the decisions that I've been discussing here. Well, the task of turning the court away from its partisanship has become more urgent now. We have an administration that regards legal constraints as an annoying inconvenience, maybe not even that annoying or inconvenient, and Congress lies supine before him. And so the court is important as a bulwark of legal legitimacy, and it's just declared that he has the power to commit crimes with impunity. Until now, the court's critics have argued for judicial restraint to try to persuade it to defer to elected officials, but the task is different now. The judges have to be induced to tell the leader of the Republican Party that he's not a dictator. And this is awkward, because after denouncing the court's activism, we need to stiffen its spine. The common thread is the demand for legal legitimacy. When the court disregards legal legitimacy, it's important that it be made to worry about losing sociological legitimacy. And this is a tricky business because the question of the court's legal legitimacy, the soundness of its legal craftsmanship, is another one of those persnickety legal questions that specialists understand and the public is less qualified to address. You don't need to be a lawyer in order to critique the court, but it helps. Which brings us to the role of the law professors. I take it to be part of my job as a citizen to tell people what I know, that the court has been misbehaving in partisan ways. So the best critics of the court come to the court as friends conducting an intervention. Rhetoric calls the audience's attention to shared values. The judges really do care about legal craftsmanship. They are not, in fact, partisan political hacks. Well, the court is not immune to sociological influence. A recent, quite good book by Neil Devins and Larry Baum to try to figure out, as political scientists, what influences the court, concludes that the court judges tend to seek approval from the legal and social elites with whom they interact. And in an age of polarized elites, this has helped to polarize the court. A conservative majority that makes right-wing elites happy doesn't need to worry about the others. There is some hope in the fact that the court's recent practice of undercutting district courts with unexplained summary reversals has produced restiveness even among Republican judges. They didn't think that this was the job that they had signed up for. They also note that a commitment to legality is a counterweight to polarization. And legality is important to the court. Quite a lot of the decisions that it issues are unanimous. But the courts, all of us are subject to motivated reasoning. The judges can convince themselves that they're acting on a legal basis, even when their judgments are heavily colored by their partisan preferences. What could shake them out of those delusions? I think one thing that is likely to get their attention is the possibility of genuine political retribution. And I think that that's the value of Biden's proposals. Now, other people have worried about trade-offs in other ways. Professor Tara Grove has written that the court faces an unavoidable legitimacy trade-off. She writes, a steadfast commitment to legal legitimacy may put at risk the court's sociological legitimacy, but at the same time, a steadfast commitment to sociological legitimacy can lead a justice to compromise the legal legitimacy of her own rulings. Today, the court faces the worst of both worlds. Its sociological legitimacy is fragile because its actions are increasingly regarded as legally illegitimate. They are, in fact, legally illegitimate, many of them, and I don't know how to remedy that other than to further erode its sociological legitimacy by calling out the misbehavior of the court and make the judges worry that whenever the Democrats are next in charge, Congress will figure out ways to check its power. But of course, retribution can come from many directions. Trump and his followers support the court so long as it is on their side. And given the astonishing number of illegal measures that Trump has taken, the court would have to be utterly lost to legality if it doesn't reverse some of them. And any such ruling will elicit rage from Republicans. When she voted against blocking an injunction that required the Trump administration to pay Agency for International Development grants, she was prominently denounced as evil and a rattled law professor with her head up her ass. That's the kind of rhetoric that's likely to be directed against the court if they thwart Trump. That was on something fairly minor. Can you imagine what's going to happen if they disagree with him about tariffs? Or if they agree with Richard about administrative agencies? Or about the firing of members of the civil service? I think the court's going to need friends. It would be well advised to make some new ones.
You have some somber words of wisdom.
Negative. My turn?
Your turn.
Okay.
Last but not least.
No, last.
Well, I promise very soon to return to our regularly scheduled programming, but I would fault myself if I didn't offer some words of thanks to those who were responsible for this occasion. Let me start with the CRCD, represented here by Jordan Baller, Michael Watson, and Jillian Barr for their sponsorship and enthusiasm for this project. Co-sponsor James Wilson Institute, who pays my bills now, at least in part, is represented here by Garrett Snedeker. And thanks to all of you in the FedSoc, which I think you're distinguished by the fact that you're wearing suits and ties on a Thursday afternoon at law school. So all of you in a suit and tie, whether you're in the FedSoc or not, thank you very much. Now, I'm very pleased to be part of this particular group of scholars. Andy Koppelman is a longtime friend, occasional debate partner, who has an extraordinary range, exhibits an extraordinary range as a scholar. But no matter where you look on the spectrum of this range, I think in anything Andy's written that I've read, which is quite a lot, Andy raises, I think, all of the relevant, important questions on whatever the topic is. Sadly, his answers are only right about a third of the time, but nonetheless, or less. But Andy's work is always worth reading, and it's worthwhile, and I'm glad he was able to join us. I also thank him in particular for adding a new phrase to my vocabulary. Now, I say this as someone who was once the pimp prosecutor in Manhattan, but I had never quite thought of this, an orgy of bribery. Now, I intend to use that in an after-dinner speech. Now, I don't know who that audience would be, but someday I'm going to use that, Andy, so thank you for that. Now, Richard Epstein I've admired from afar as a scholar for a very long time, but today I met him in person for the first time. I'm glad to have done that, and I appreciate his remarks. I should say we've already begun to bond over a shared boyhood in Brooklyn, New York. That would not be the Brooklyn that you think you know as the home of crunchy 20, 30-something singles who just want to find an olive oil shop. The Brooklyn that Richard and I know is actually a loose confederation of ethnic villages, neighborhoods. But I also want to thank Richard especially because he talked about being a Roman law professor and Trump not remembering or Trump having a short memory. I've actually come to think that Donald Trump, imagines himself to be a Caesar. And now Richard Epstein says the guy is insufficiently Roman. Well, go figure. Roman law.
The assassins thought he was insufficiently Roman.
That's it. And then, not least, Adam MacLeod, who is one of my most impertinent former students, but also one of whom I'm most proud. And I'm very pleased he was able to be our moderator, although I think the job was pretty easy work. It's all inside work, no heavy lifting, and the panelists have been pretty well behaved.
That's you're here. Yeah. Correct.
So back to our regularly scheduled programming. Although the loudest and maybe most persistent critics of the Supreme Court's legitimacy these past several years have been on the left, and those criticisms have been fueled, understandably enough, by a string of conservative, let's call them, results in high-profile cases about abortion, guns, religion, affirmative action, administrative state. But I think that the gravest threat to the court's legitimacy comes from sectors of the right, where hostility to the rule of law itself festers and even flourishes. And insofar as I'm right about that, then hostility or questions or challenges to the legitimacy of the Supreme Court are sort of incidental damage, or you might say lesser included damage, of damage to belief in the rule of law. So Donald Trump came into office earlier this year firing both barrels of executive power. Now, it's tempting to view his aggressive assertions of authority as an invigorated departmentalism, and at least the law students here, I hope, know what departmentalism is. Maybe a departmentalism on steroids. That is, where the president exercises or possesses and exercises a share of the project of giving meaning to the Constitution. Now, this attempt, thinking of Trump as a muscular departmentalist, this attempt to assimilate Trump to something like ordinary constitutionalism is understandable, but it doesn't fit the facts. The president candidly presents himself as acting in good faith and energetically, directly for the common good. He appeals to the American people for approval of what he does over and against the delaying mandates of courts and the restraints of mere law. Trump is not practicing departmentalism. His is a calculated attempt to acquire new constitutional authority by an unmediated pursuit of what he believes, honestly, to be right, in derogation of law, if need be. And he does this, at least one big way, by declaring an emergency, an insurrection, a predatory incursion, or a rebellion at regular intervals. It's like having the Youngstown Steel decision on your docket every day. Now, this, what I'll call routinization of action, contrary to the Constitution and or statutory law, taken for the sake of the common good, is unprecedented. It is beyond my pay grade to judge whether it presents the court with its greatest challenge ever. But how the Supreme Court handles this challenge, assuming that the justices recognize the challenge for what it is, again, not departmentalism, acting directly for the common good, will do more to settle its legitimacy than anything else on the horizon. Now, fortunately, momentousness does not equal complexity. My judgment is that if a specific action or order of the president is alleged in some direct legal proceeding or as a necessary step in some other valid proceeding, but if it's alleged to be unconstitutional or unlawful, the courts should rule on the allegation according to law, text, precedent, etc. If the president rejects that ruling, then in due course, if the case is presented again, the ruling should be repeated. That's what the Judicial Department does. That's what it's for. And I think the quickest way for the court to lose legitimacy is to proceed in some other way, by, for example, entering into a debate with the president or his surrogates about whether there is an emergency or an insurrection or a predatory incursion, or a debate about what the common good just straight on requires. Now let's swing to the left. The central illegitimacy charge from the left is that the court has become not exactly or not chiefly partisan, although that's often alleged and there is evidence of it. Andy supplied certainly more than a little. But I think that the charge is broader than partisanship, and it's inclusive of partisanship. The court is simply, the charge is, the court is simply out of touch with the people in a way or to an extent that undermines the court's legitimacy. The justices are not producing constitutional law that's reflective of and fit for 21st century America. Again, Andy picks up on this and fills in some of the nature, the content of the charge. Now, the corrective to this deficit is, as the left presents it, some form of popular constitutionalism. Not that the demos would somehow actually have access to the levers of power, some power or authority they don't presently have, but that the court should incorporate contemporary values or popular consensus or pursue, you might say, sociological legitimacy in a way it doesn't presently do, and to make, I'll call it, popular attitudes a source of constitutional law. Now, I have 4 criticisms of this position, and I urge you to reject it. Okay, first, this promise of popular constitutionalism to be more democratic, you might even say to produce a more democratic, small d, constitution, I think is unlikely to be delivered. The standing threat to all such proposals, again, popular constitutionalism, is that they collapse into a kind of aristopopulism. Rule in the name of the people by Platonic guardians in plebeian robes. I think this because the concepts involved in the popular constitutionalisms that I've looked at by various authors are homespun, murky, malleable. So much so that even well-intentioned practitioners are likely to confuse what the people really think with what the practitioner, the judge, practicing this form of constitutionalism, think the people should think. Now, this is what happened to Justice Marshall, Thurgood, not John, when he sought to deconstitutionalize capital punishment in the early to mid-70s by appeal to evolving standards of decency. Now, this was the governing translation at that time of cruel and unusual punishment. Marshall found that the actual people were incorrigibly in favor of the death penalty. Thus, the Marshall hypothesis, in quotes, went into the books. Although the people might favor the death penalty, they wouldn't favor it if they were actually fully informed about it. So in other words, and in sum, I think that popular constitutionalism doesn't have sufficient guardrails around it to avoid or to make it stay in its lane, and that it's going to be a pretty straight shot to what I would call living constitutionalism. Second, criticism. Whatever else one could say for or against the popularistic proposal, to the extent that it licenses the replacement of a constitutional norm whose public meaning at the time of ratification remains clear, if it's to replace a clear constitutional norm with an incompatible norm, which is judged to be more in tune with the times, I just think that should be rejected. Again, there aren't many faster ways for the court to undermine its own legitimacy than for it to eschew norms with sure constitutional sanction in favor of better norms. Sticking to the discipline of reasoning from authority is sometimes hard, and the temptation to deviate strong. But to consciously reject that demanding regimen is to reject the foundation, I think, of judicial legitimacy. Besides, third, what today's populist left advocates of a democratic constitution seem to have in mind is very much like Madison's proposed Council of Revision at Philadelphia, which I judge to have been rightly and the historical record shows was decisively rejected at the convention. Maybe most important, I think of what the populist left critics, I think much of what they say they want are after the kinds of correctives that they think are required. And almost all of what they should want could be delivered effectively without entering the boggy terrain of popular constitutionalism. I think a constitution up to the times, with the people, of the people, for the people, 21st century constitution, if you wish, could be produced by a healthy, not even an aggressive, or a robust departmentalism, accompanied by a Congress that's not actually sleepwalking. And add to that, or replace that suggestion, with a much more extensive, what I would call Thayerism, if you've taken Con Law 1. You know, James Radley Thayer in the late 19th century became associated with, because of an article he wrote in the Harvard Law Review, with the clear mistake rule. But again, apart from departmentalism and a wide-awake Congress, a much more widespread approach to constitutional decision-making by judges, which reduced the judicial profile, so to speak, by holding what Thayer held, that the court should set aside at least congressional legislation only in a case of a clear mistake. This bears some superficial resemblance to the rational basis test, although it's really fundamentally quite different. But it has much the same effect. But the effect of all these suggestions would be to supply or open up an avenue of sort of popular participation through the people's representatives, introducing the representatives to the project of constitutional lawmaking. Now, it seems to me the core of any sound account of the court's legitimacy is that it should behave as does and should a court. The difficulty, you might say, is that we have come a long way from the world in which Marbury presented the matter. Marshall described judicial review as no more complex than finding the law of the case and applying it in ordinary litigation between private parties. Now, in Marbury, there weren't private parties, but the court treated it as if it could be analogized to a dispute between private parties about the delivery of a deed. Then, and for a long time thereafter as well, the operative activity within a constitutional case was inert. Through the 19th century, I think, a declaration of unconstitutionality was little more than that the statute, for example, was contrary to the Constitution, and so the statute was simply to be ignored. It was as if judicial review meant a veto. But constitutional litigation doesn't look anything like that now. It's not ordinary litigation in any ordinary sense of the term ordinary. It is typically a full-dress battle of experts in that sort of lawsuit, often with a state or federal government party, or both. It does not drive towards the simple operation of old, treat as an impostor, as a failed attempt at lawmaking, some statute, some alleged law. We have doctrine, we have tests, we have rules and standards. The point is the court now, and for a long time, has made law. This is res nova, the new thing. Our apex court typically makes law of huge consequence in constitutional cases. I think that the court's legitimacy hinges upon recognizing and speaking candidly about its lawmaking. And in that sense, the political, and I mean to put that in a kind of precious set of scare quotes, it's political, although not partisan, work. Anything less, like the total denial of lawmaking, judicial lawmaking, characteristic of contemporary constitutional conservatism, breeds suspicion and then rumors of illegitimacy. But note well, I speak here of lawmaking properly judicial, of the creative contributions to social regulation by courts for the sake of the common good, but in the way that courts do that, which is to be securely and palpably distinguished from the way legislatures do that. The fact is, courts make law. I hold to that. Justices very often decide matters according to doctrinal considerations which call for making authoritative choices about what the common good requires. Indeed, the move from constitutional text, free speech, establishment, Second Amendment, you name it, to doctrine, well, the Lemon three-part test, the O'Brien rule for time, place, and manner. But the move from text to doctrine is a form of lawmaking. There's a choice there about how to implement the constitutional text, how to make it practically effective now, or how to apply it on these facts. That move, whether you call it lawmaking or not, is a choice, and it's creative. It's not determined by what came before. It's not deductive. It's informed by reason, to be sure, and facts and evidence, but it is a choice. Choice here is another word, as I'm speaking, for lawmaking. Choosing doctrine A as opposed to doctrine B, which is favored by the dissenters, by hypothesis, and giving reasons why A is to be preferred to B. Well, that's lawmaking. Now, sometimes the court relies upon a popular consensus, like in its definition of obscenity. Sometimes it talks about the consensus or practices of the states, as it did when it made the rule of jury unanimity in the Ramos case, something universal. There are a couple of outlier states. But very often, the justices are called upon to decide, according to their best lights, what the common good requires. This is the case, for example, wherever the doctrinal norm is fairness, understood to be a species or another expression for the golden rule. When this is the case, and even though courts would be making the authoritative judgment about what fairness requires, these judges would be judging what it is that people now consider to be the kind of thing they are willing to have imposed upon themselves or ones they care most deeply about. That's what the golden rule is. And this has nothing to do with the framers or with Blackstone, with Cooley, or even with Roman law. It's an eyes open, up to the moment, practical judgment of what is to be done, which brings us finally face to face with what I call the neo-formalism of contemporary constitutional conservatism. I think this project, contemporary constitutional conservatism, it seems to me it repudiates altogether the legitimacy of courts making law. And you can find chapter and verse in the opinions and in the off-the-bench writings and speeches of the justices, the conservatives. We don't make law. We find it and we apply it. Law is for legislators. We don't do policy. We don't do values. That also is what you do, or that's because that's what you do when you make law. But we don't make law. So we don't need no stinking values or policies. Now, I think, well, I suppose you could take a poll when I'm done. Even first-year law students see, by no later than the semester's third or fourth week in con law, that the Supreme Court very often, even habitually, makes law. And it's ironic that the court denies it makes law when it does, because the conservative project, the denial, is surely itself a legitimacy narrative. It's tailored precisely to the present moment of moral pluralism in our society. Constitutional interpretation and adjudication lie downstream from what amounts to what is a legitimacy narrative. No matter how slathered in amber or draped in historical learning and opinion is, I say it's driven in the end by the commitment of the conservative opinion writer that the court, above all things, appear to be neutral, nonpartisan, not making value judgments, that the law of this case is being made by somebody, anybody, according to any opinion or any text writer, but not being made by the judges. That's what I'm describing as a legitimacy narrative. That's what I think is on offer from the conservatives. And I think it's fundamentally wrong-headed. Now, although the conservatives dive deeply into history, especially that of the founding, they're actually only occasional originalists. Their uses of history are propelled principally by a peculiar doctrine of judicial moral restraint. They take mitigating the risk that they might make policy or law, or be seen as making policy or law based upon their own moral values as the overriding norm of their behavior. They have, as most of you know, repudiated doctrine even in favor of history and tradition in religion and gun cases, precisely because their judgment is doctrine opens up the possibility of judicial value judgments. Fourth Amendment cases, among other cases, represent a conscious effort by the court to find something in the founding, whether it's in a common law treatise, Blackstone, or very early opinions, to try to answer questions about search and seizure in a digital world without appearing to make any judgments about reasonableness of their own. But I think the courts should recognize and say, and then belly up to the task of justifying their lawmaking interstitially based upon their best understanding of what justice and the common good requires. They should do this as judges do and as they should do, which means lawmaking that's not only interstitial, but always within their limited jurisdiction, according to the stylized rules for coming to know relevant facts, or some of them, the way it works in lawsuits, while employing techniques of legal learning and reasoning as far as those valuable forms of artificial thinking can take them, and deploying, finally, judicial remedies properly limited in scope and effect. This kind of proper judicial lawmaking is not a threat to legislative prerogatives. It portends no usurpation of legislative authority. Now, the conservatives tend to say that as judges, they are obliged to know, or can't know, anything stable and true about value, human flourishing, or even metaphysics. They seem to think this is the way to mark them as reliably different than legislators, who should and do make that kind of judgment, or those kinds of judgments. But I submit that judges should not think of themselves, nor should we think of them as knowing less about human flourishing, justice, metaphysics, the common good, than anybody else does. I think judges should recognize that the pertinent distinction is not between knowing and not knowing the good and the true, but the distinction is between the nature of legislative lawmaking and proper judicial lawmaking.
Well, thank you, Jerry. Obviously, if you came to this Federalist Society event this evening hoping to hear a full-throated defense of originalism, you're going to leave disappointed this evening. But hopefully this has provoked some questions. Well, I think we could all do it. I hope you'll think of questions if you haven't already. We're going to open up to Q&A in just a moment. I'm going to take moderator prerogative for just a moment. And just put a couple of questions to our distinguished panelists. And the first is, I wonder if Richard would accept an attempt to make a connection between his presentation and Andy's along these lines, that one reason why we might allow longstanding usages to become constitutional doctrines notwithstanding their lack of grounding in the Constitution of 1789, is precisely the link that Andy is trying to help us draw between sociological legitimacy and legal legitimacy, that it might actually run in two different directions, as Hart suggests, that to the extent that rulings of the court become accepted as legal rulings, that this can take on the nature of, or be thought of as a source of legal obligation.
Look, I mean, the question you're asking to some extent is to what extent is custom law? And this is a very difficult question. When I was young and less self-assured than I am today, nobody gets the joke. You get the joke. What happened was I was sort of deeply skeptical of the notion that a form of custom could represent law, because I was raised, I thought originally, like Hart was, in the Austinian tradition, in which a law is a command of the sovereign, as embellished by Kelsen, is saying, all you look to find out what's a law is the source of its authorization, not its merits. And so you could see two texts that are identical, and one which has been blessed by the legislature, the other's not. They read the same way, but one is law, one is not. As I've gotten older and so forth, a couple of things have become clear. One is this is an utterly inaccurate description of the way in which international law operates. And as you start to understand international law, it turns out that it's a much more coherent and cohesive body of doctrine than one would otherwise have thought. And so, for example, if you want to start taking one case, coming out of the Spanish-American War, there were all sorts of disputes about what was permissible by way of privateers and so forth. And in a case called the Cabana, or whatever it was, there was an American privateer that took a coastal fishing boat that was Cuban and captured it as if it were a prize. And they come into the United States Supreme Court, and Horace Gray, who's become the jurist of the moment because of all the stuff on birthright citizenship, said, you can't do this. You check all the bodies on the international law, and they're uniform against it in every which way. And so what I did is I went back and checked it, and the son of a gun was right. The level of variation that you found in custom when they were relatively coherent earlier on than it is today was extremely important. And that as you started to look to these usages, they were very powerful. To give you but one illustration, which starts with Roman law, the rules on avulsion and illusion, violent changes and gradual shifts in property are the same in early Roman law, medieval law, American law, disputes between states and disputes between nations. And although there are disputes over the application in particular cases, it's an absolute unanimity. So I do think that that's a problem, but here's the difficulty. Customary law moves very slowly. It essentially accretes in some orderly way. And when you get something like some of the Trump originals initiatives, you don't get that particular pattern for doing it. And just to give you an illustration, you can't use a customary argument to explain that Roe was right. You can use a customary argument to say that these administrative agencies have cohered, and you want to do it. You can't even use the customary argument to explain about guns when the regulatory history has been exactly in the opposite. So what happens is when you take these custom and prescription rules, they're not self-defining in everything they do. But if you kind of do the correct analysis on them, it turns out that you discover they're indispensable for the way in which you start to go. And this sort of relates a little bit to Jerry, because I'm not quite sure how he would come out on this. Are these the kinds of things that judges do? Can they be the sort of things that you do without having a value, by having a value-free situation? No, all of these things are value-laden. I wrote this very long history of Roman law, or natural law history. By the way, the journal you used to run was called the Natural Law Forum at one time. And indeed, the moment they changed the name, they lost their internal integrity in a deep sense of that word.
Thanks for sharing that, Richard.
But you agree. You agree.
Take it under advisement.
I mean, because...
Oh, look at the time, Ed.
All right, but anyhow, that whole tradition has been lost. And the custom is a way to try to bring it back. And we don't do enough of this. So let me just end in one point. So what are the things that I think just go completely crazy under this standard? I think the effort to create these administrative court judges in like oil states. I think the tariff stuff is just way off the line. I think shooting up people, calling them narco-terrorists, is against every principle of international law and so forth. And so what's happened is the guys who are practicing it today don't believe in any of its premises. And that, I think, is the source of a crisis of legitimacy that the young radical, Mr. Koppelman, points to.
Jerry, would you mind briefly responding to Richard's question?
Yeah, I'm distracted. I'm trying to think of when it was that Richard Epstein was not self-assured. I'm figuring it was when he was wearing short pants
Oh, no.
on the streets of Brooklyn, waving a Brooklyn Dodgers pennant.
Well, you're
Even
wrong
that I'm
about
not
that.
sure.
I actually root for the Yankees and love Jackie Robinson. I was a contrarian even then.
I would expect that Richard in utero was already Richard. I would say though on the role of usage and sociological legitimacy, it's just not the case that there are no originalists on the panel. I'm an originalist. I think that you should follow the original meaning of the Constitution, but I read it the way that Jerry reads texts. Certainly in the written thing that you circulated, it became pretty clear that Jerry is a purposivist. When we look at texts, the meaning is to be had by grasping the point, the purpose, the good that a constitutional provision is wont to do. There are some constitutional provisions that state really clear rules. Birthright citizenship is a rule. No third term for a president is a rule.
Is a wrong statement of
But there are some provisions that you just got, no law respecting an establishment of religion or abridging free exercise thereof. You got to figure out, why is it there and make sense of it. And so some provisions in the Constitution don't state rules. They state general principles, or they state standards. What is an unreasonable search and seizure? So I think the best of the originalists working today, in my view, is Jack Balkin. It's just
everything wrong.
it's, the
Perfect record.
But then, if what the court is doing is crafting doctrine in order to implement the purposes of those general standards, that's a task where it seems to me that popular constitutionalism has got a role. That when the court is engaged in lawmaking, trying to think about what will make sense for this population, what will be acceptable for this population, what kinds of results what kind of consequences are going to work. Clearly, something like that was in the court's mind when it decided not to revisit the same-sex marriage decision.
Yeah.
And it seems to me that that's entirely appropriate. So it seems to me that the framework you've offered is not as hostile to popular constitutionalism as you've suggested. I think that that even has implications for abortion, but I don't know if we want to get into that.
Well, you can get into anything you want. Jerry?
Is there
Yeah.
a microphone circulating for
yeah.
audience questions? Great.
I mean,
Yeah.
I should say, I guess
Oh,
it's
Jerry.
late enough in the day to be paradoxical. Nobody minds at this time of day. But I actually am an originalist. I just wish the Supreme Court were more originalistic and less interested in history.
May I make
That's one of the good takeaways of what I was saying in the last few pages of my remarks is the court is substituting history, that is something somebody else did a long time ago or said a long time ago, for what instead should be doctrine and application of doctrine undertaken largely along the lines Andy described. So we have a free speech guarantee or we have a rule against establishments. What do we have to do to implement that in 21st century America?
Look,
This is
I
true
want
very commonly in
One
criminal
very
procedural
strong,
codes.
one's very strong exception. One of my least favorite cases is a case called Prigg.
Yeah.
It has to do with the Fugitive Slave Act. And this is a terrible set of affairs. But if you're an accurate originalist, you take a bad statute and every interpretation is as bad as the statute you're trying to deal with. That is, originalism is trying to implement what they said, and so you don't want to play the Dworkinian trick, which is every time I get a bad statute, I'm clever enough to make it into a good statute. You have to do is to recognize the ugliness of this. And so, for example, I'm writing this book on birthright citizenship, and the horror begins in 1790, where the statute on immigration, on naturalization is all white free persons may apply, nobody else may apply. You can't run an interpretation of that provision which says, oh, white meant white, black, and Asian. And so you have that all the way through the equal protection arguments in 17. It wasn't changed until the 1870. So you have to be careful about this. If this is only a classical liberal constitution of the kind that we like, you're great. But you start looking at the rest of the 14th Amendment, well, the 3/5 rule is still there. You're allowed to exclude blacks from the numerator, so long as you exclude them from the denominator. But you don't have to give them the vote if you're prepared to take a reduction in the kinds you have. Well, that's part of the thing. Another rule there which says only male inhabitants count for certain kinds of purposes. It's a much more somber situation. Our American Constitution bears a heavy legacy of slavery, much more, and racism, much more than we want to admit. And there's always a tendency in interpreting the 14th Amendment like Jack Balkin, as none of this really mattered. Every single adverse case he ignores in the book. Everyone. And you're my research assistant, right? That's right. Did that in fact happen? Yes. Thank you, dear. Let's just load the audience now. No, I do think it's a very important corrective about this. We don't only have originalism for nice clauses, we have it for bad clauses as well.
I think the young man wants to be employable after this.
Yeah, then you could keep your name. I won't give you an acknowledgement. Yeah, I know.
Questions from the audience? There are students here who I'm sure have objected to something said this evening.
No, you could ask a question which praises us.
Or that. Not that we need it, evidently.
This is an inquiring bunch.
Oh,
Thank you. And then there's got to be a break the storm.
Hi, I have a question for Professor Koppelman. You mentioned that you think the main thing that's driving the questions about legitimacy for the Supreme Court is their procedural things.
It's the main thing I talked about.
Right.
Yeah.
And I think I agree with that in buildings like this, but why do you think public discourse is so much more centered around like the Dobbs opinion rather than procedural things like that?
I think that people thought that the Supreme Court was going to protect rights that they regarded as important to themselves, and so to announce to women that they, one source of legitimacy is what people feel themselves entitled to. So, I guess that this goes to the question of usage and what people, as a matter of background understanding, think themselves entitled to. One source of substantive due process rights, the whole history and tradition source of due process rights, the court looks at what people, in fact, for a long time have thought themselves entitled to do. So that deeply rooted in our nation's history and tradition phrase, which the court in Dobbs relies on, it actually was crafted by Lewis Powell in a case called Moore versus City of East Cleveland. Yeah. That's where it first appears in the U.S. reports. And the question was whether, I believe that it was a great aunt could live with her great nephews. And there was a statute that said that a family in this particular area could only live at a certain level of consanguinity. And the court said, nah, there's been a long history of people forming these extended families. This is just the way that something the Americans have thought themselves entitled for a long time to do. And so, therefore, it has constitutional status as a matter of usage. That's a fundamentally different procedure than the procedure that the court used in Dobbs, where in Dobbs the court said, if we want to find out what Americans think is important, we're going to look at the statute books. And if at the time the 14th Amendment was passed, all of the white guys in legislatures thought that it was okay to prohibit abortion, then that's what Americans in general thought. So just a fundamentally different procedure than the one in Moore. You'll get your turn. Actually, for most of American history, women had no difficulty getting abortions. It's something that they thought that they were entitled to do and did, with exceptions around the post-Civil War period and in the post-World War II period. So if you were to follow that usage-based procedure, I think that it creates a problem for the reasoning in Dobbs. So the upshot of Dobbs is that women have taken away from them something that they think is fairly important. I imagine that if there are women here who are first-year law students, they understand that you're in kind of deep after you've paid the tuition for the first year of law school. You kind of hope that you'll be able to finish and get otherwise you've incurred an awful lot of debt for no reason. Well, if you get pregnant the summer after your first year and you can't get an abortion, you're really in trouble. Putting women in this kind of situation is going to have an impact on legitimacy.
Okay, I'm going to disagree. One of the things I will say is actually I wrote an article about abortion back in 1973. And what happens is I think it's a very different situation. Recall what I started to talk about prescription is a situation where you get common practices that are widely accepted. When it came to abortion, if you looked, every state in the Union had a statute or a common law rule which rendered it illegal, often with very serious punishment. And you had a practice which was very enigmatic, which is you occasionally would punish doctors, but I don't think there was a criminal prosecution of a woman, but it had taken place for a very long period of time. So what you did is you had yourself a very ambiguous kind of situation. The conservatives said, and I mean, they said this is just illegitimate usurpation. There's no federal control. They cited people like Hubert Humphrey, who in 1968, in the presidential campaign, was said, well, Mr. Humphrey, what are your views about abortion? He says it's a state law issue. I don't even know what I would think about it. And so when Al Alshaw told me the story about when they mooted the people who were going to argue for the favor of abortion, the entire panel at the University of Texas Law School could barely constrain its utter amazement at how weak the case was, how utterly improbable it would be that it was won, and anybody who had been around the legal profession at that time would have known it. And then what happens is it comes out the other way, and to the people who said, well, I'm not sure which clause of the Constitution is involved in this particular case, but it really doesn't matter. That drove originalists, textualists, traditionalists, whatever, up the wall. And so what happened is, unlike some of these other cases having to do with the ECC, the ICC and so forth, the Roe v. Wade was contested fiercely from the day it came down and so forth. So now we do the other part of the analysis, and if you start this now, 2022, you got some legs on this. If you actually look at the sentiment in the United States at that time, it was basically 2/3 of the people thought that maybe abortion should be illegal, but 2/3 of the people wanted to have it anyhow, and so there was a real ambiguity between their legal and their moral judgments. And what happened is Andy won. That is when Justice Powell said, and he did say it, I'm not taking into account the politics. The politician in me said, you should understand what every conservative does. If you guys start messing around with the politicalization of abortion, you'll lose all of the highly professional women and men who basically believe in economic liberties and in an abortion right, and you're going to lose the next election, which is kind of what happened. So there was just an absolute conflict. So what happens is you take either the sociological level or the legitimacy level, and both of them are muddied at all times with respect to the debate. And I could remember one day I was actually in Justice Brennan's office with Michael McConnell, And it was just after Reagan had won, and he starts talking about the abortion case. And it was really quite striking the way in which he treated it. He treated all the objections that anybody wanted to raise as a kind of a standing joke, not worthy of another second worth of consideration. I really felt that I was in the sort of political headquarters of the New Jersey Democratic Party, listening to the guy talk. And that's what drove a lot of conservatives crazy, is they really believed that Brennan did not believe that what he was doing was constitutional law. They believed that what he was doing was responding to a political constituency. And the ultimate irony was this was a Catholic guy leading the abortion case. So I don't know what to make of all this history, but what it does show is that the categories that we started with such confidence at the beginning, this is a case in which the sociological and the legal were on both sides of the issue at all times. Somebody else has to have
Gerard.
a question.
So, to my knowledge, the reason why we're even having this discussion today is because one political party has decided to make a fuss over having to live with the terms of the debate that they wanted to set down for the other side to have to live by. And the example I come up with is how years ago, Chuck Schumer, and even before that, Joe Biden, made it very clear that they would not hold hearings on Supreme Court justices when the opposite party controlled the Senate to where the president's party controlled the nomination in an election year. If it would ever happen again after the experience with Clarence Thomas. When the scenario happened again, Mitch McConnell made it very clear he was abiding by the Schumer standard or the then Senate Judiciary Committee Chairman Biden standard. Because of McConnell's, as Professor Koppelman says, shrewdness or gamesmanship, we are now dealing with the consequences of political fortune favoring Republicans, making Democrats live by the rules that they set down. The question I have for the panel is, were the shoe on the other foot, meaning a Democratic Senate would have prevented a Republican from holding hearings on a Supreme Court justice, in a counterfactual world, would the legitimacy of the Supreme Court be being called into question? I see a fundamental asymmetry at work where I don't think that calls to pack the court, which, by the way, suffer from a 70-30 divide on public opinion, would provide any sort of cover for a commission that Professor MacLeod described to pack the court, which, by the way, the composition of the commission was something like 5-1 liberal to conservative in composition. And then, in addition, calls to not only pack the court, but also were backed up by actions by President Biden on student loans, on the eviction and on the eviction moratorium of outright defiance. Perhaps not in like the classic departmentalist sense, but in like pure constitutional intransigence. So I asked the question that perhaps is on the minds of people in the room who are students. They may be afraid to ask, but I'm going to be the turd in the punch bowl and put that before the panel.
Well, there's a Shakespearean line called "A Plague on Both Your Houses." And
I
go ahead.
take it implicitly, you're saying, holding, that the Merrick Garland, Amy Coney Barrett theater is contributing significantly to this blowback. I doubt that's true. I don't doubt that it's sometimes said, or maybe often said, that the Republicans have been playing politics with the Supreme Court in a way that's egregious. I think that's more of a make-weight. I think the substance of the illegitimacy complaints on the left are well described by Andy. It's the result in a certain number of cases. To some extent, it may be the abuse of procedural mechanisms like the emergency docket. But I tend to think that confluence of events, Merrick Garland, Amy Coney Barrett, is not really, it's just a make weight. And the other thing I'd say is, which is true about the court and about how people think about what the court should do. And I'm inclined to think it's not a helpful thing to be thinking, namely strategic gamesmanship, in most direct connection to what we're talking about. Conservatives, politically and constitutionally, might listen to what I said and say, yeah, that's great, but don't you understand? If you want the court to embrace lawmaking, what are you going to say when the Supreme Court in 10 years brings back abortion or brings back, you name it, affirmative action? That's what I mean by strategic gamesmanship. It's not so much that we think this is the right way to go, the alleged or asserted value neutrality, but we think that's the best strategic position to occupy so that we can consistently criticize people on the left, maybe Justice Jackson, who would implement her own values. And I think I understand the logic of that, but I actually think it's unsound, because what's lost in all of that is the actual Constitution and what it means and the way it should be implemented now. Constitutional law becomes the effect of political gamesmanship. And the other part of it is I don't think it's a way for anybody to fruitfully think about it, because I've said to some of my conservative friends who say, yeah, you're right, but you shouldn't talk the way I talk for this reason. So we have to be able to tell. I say, what makes you think that if the left ever gets a majority on the Supreme Court, they'll care that you're saying to them, oh, you're not playing by the rules that we used to play by. I don't think there's any reason to think that would actually have any effect upon the left were it in charge of the court. I mean, the fact is, anybody who makes law, whether it's a court or a legislature or constitution makers, there's a risk that they'll make the wrong decision about something. But then the criticism of that is, you've made the wrong decision about how to implement the Establishment Clause, or you've made the wrong decision about pornography, or you're just plain wrong. Not every mistake, you might say, that courts make is strictly legal. Sometimes they make philosophical mistakes. That's the burden of being a Supreme Court justice, to make those judgments and suffer criticism of what you do or say on philosophical grounds.
Look, I think that's a nice theoretical stuff, but let's go back.
Right.
This is all getting even. The Democrats started this with Miguel Estrada, and they deliberately blocked him because they said, this man is too able, and if he gets on the court, we'll have a Hispanic Republican, which we can't tolerate. Off he goes. Then what happens is Harry Reid is met with some objection. I think it was to Nina Pollard, which we understood, fully vindicated in one sense, not in another, because actually sometimes, unfortunately, I have to agree with her. But what happened is he said, I'm getting rid of the filibuster for that. And then McConnell says, I'm doing it for the Supreme Court. Now, I'm going to tell you my view. I think it is correct to get rid of the filibuster for all appointees. You have to fill these seats. I don't mind it for legislation, because if somebody tells me we can't live without this new statute, I can basically say quite confidently, yes, I can. And so, but you have to fill seats, and so I wanted to do it that way. I would have changed the filibuster rule with the recent shutdown. I don't think on any continuing resolution you should allow a filibuster, because you're not trying to stop a good law from going into effect or bad law from going into effect. You're trying to wreck a minority position. So I actually wrote something taking that view, and I'm quite unrepentant about that. But what's really happened is there's this funny word that we used to believe in called comedy. C-O-M-I-T-I. Why?
I thought you meant being funny.
No, unfortunately, tragedy. But comedy was part of the cultural tradition, which is we give a little to you when you're in power, because you're going to give a little to us when we're in power. And so we have an intergenerational pact, which allows everything to kind of go through. And what's happened is there is zero comedy today. So everything is a single period game. And when it's a single period of game, they're always going to be fought to the bitter end. And so my rule suggestion on this, I thought that both McConnell and Reid were right when they got rid of the filibuster on nominees. And I wish they had done it on this thing. It would have saved 43 days of American misery, including the possibility of my not being here if this had been extended another 10 days. when I say plague on both your houses, I can't tell you how much I loathe most of the Biden decisions of the ones that you mentioned. But that does not diminish my utter contempt for the Trump decisions. I'm a classical liberal, and I think the position that I would take right now, I have no friends in high places.
So I think I was the one who used the term gamesmanship. What I had in mind particularly was the stalling on Merrick Garland, and not because, well, we're Republicans as a matter of just pure politics, we don't want him to get nomination. The argument was made, look, we got an election coming up. We should let the American people decide. When we're this close to an election, actually it was a year away, but still, this close to an election, it's just wrong not to let the American people decide. That offered as a general principle, which utterly evaporated when Ruth Ginsburg died. And Barrett was rammed through. Now, the question, I guess but what I was concerned about was how a Supreme Court justice behaves. And it seems to me the appropriate thing for a Supreme Court justice to do, whether they got there through gamesmanship or however they got there, they'd say, well, all right, however the process put me here, here I am, I need to do my job. And if gamesmanship is what puts Barrett on the court, that is not a complaint against Barrett herself. It's not her fault. She's just trying to do her job. What I do think that the court should worry about, given the partisan spin of how they got there, is to try to signal to the public we are not partisan hacks. And when the court is extremely supportive of presidential power when Trump is in place, and then suddenly deeply skeptical when Biden is in, and then becomes deferential again and undercuts district courts, the district courts which are resisting this partisan trend, but the partisan trend is really stark at the level of the Supreme Court. That seems to me to be even more of a problem when the court arrives already under suspicion because of the partisanship, which again, it's not their fault. They have some obligation to try to rehabilitate themselves from that, and going so heavily partisan in the other direction and undercutting their own district courts, including Republican judges who are facing death threats when they rule against Trump, seems to me to be a poor way of fulfilling the job description.
I agree, but let me go back. I didn't get a chance to talk about before. We're trying to figure out how the Supreme Court goes crazy. And the two cases I did not mention are the Oil States case and the Arthrex case. And what is it that is done, and it's by Democrats and Republicans alike, is first of all, they passed the American Invents Act, which is bipartisan support, which allows the PTA to hear cases that are in district court at the application of a defendant that they would like to be decided before an administrative agency. Well, what's this about?
With no preclusive effect, by the way.
Yeah.
You can bring as many as you want.
Yes, you could,
Seriously.
so with that, you could bring them into this body, and then, well, how are these, quote, judges appointed? Well, what happens is the head of the PTO says, I know what the case is, I know which way I wanted to come out. Here are three guys going to put on this court, often not lawyers in the patent space themselves, but other field. Here are my judges. Then it turns out he looks at this, said, 2-1 against me. Now there are 5 members of this panel. Now, 3-2 against me? God, I'm bad. Well, I'll put myself on the panel. It'll be 4-3 in my favor, which is exactly what happened. And there was not a single justice that was prepared to look at this from either party as a due process matter. They said, it's an appointments clause matter. It's a separation of powers matter. And then in the Arthrex case, all this goes through. And the Chief Justice engages in what I regard as simply inexcusably immoral behavior. What he says is, oh my God, these guys are in the executive branch. These judges are supposed to be independent, but since they're in the executive branch and there's a unitary executive, the real question is, can the president or his delegate just fire these guys when they're judges because they don't want to play the game. And he says, absolutely right. If the statute gave them permanent independence in this agency, I'm going to say that that part of the statute is unconstitutional, so you should fire them. So he says essentially independent judges are now treated as executive agencies. Instead of saying this whole thing stinks to high heaven, we do not allow under the Constitution to have a full set of courts inside the executive branch, which you can manipulate at will. This was done 2021. I don't know whether it was Biden or whatever it was, but this got 7 votes or something in the Supreme Court. And this indicates, to my mind, a kind of a total craziness. The rule is essentially the courts are supposed to be courts. I can live with Article I courts that are independent for historical reasons. I don't quite like it. But I can't live with the idea that somehow the definition of a court is somebody that the president can fire when he doesn't like the decisions that disagree with him. Well, where is the protest on that? There was none. Absolutely none. I'm used to. So what happens is this is a bilateral problem on the way in which the justices and the lawyers think about this issue. And so I remember I started at the beginning, and I'm going to say it again. It's maybe the last thing I say ever. I'm going to say the simpleton, Justice Black, got it right. When he says, I don't see any express power under the Constitution, any implied power under the statute, any express power under the statute, you can't do it. And we forgot that principle.
The only thing I'll add, there's lots of things that you got into in your paper that you weren't able to reach. The only thing that I'll add is you had a quotation from Article 1, Section 8, which explicitly assigns to Congress the power, to Congress and not to the president, the power to lay and collect taxes, duties, imposts, and excise.
The taxing power. I mean, look, the scandal, see, I didn't keep my promise. The scandal of the Supreme Court, I mean, it was a true scandal, is what happens is the district court, they decide that the president's absurd. I don't want to go into the reasons why he's an economic literate and a immoral person and so forth. But the fundamental question is, do you then give a preliminary injunction? And the court said no. When it was overwhelmingly clear that this guy has no idea what he's talking about. So what goes place is they won't stop it, and it's going to go on for another 6 months. And then when they strike it down, they say, what are we supposed to do with all the tariffs we collected? If you don't stop illegal behavior on the presumption there, because somehow you give deference to the president when he's wrong, it's all over. And so the basic rule has been there's no deference to the president on determining the scope of his power. You just do what that moron, Justice Black, did. Said, I'm just going to play it straight. And, you know, he got it right, and all these other clowns got it wrong.
Clearly, all of this began to go wrong when we stopped teaching Roman law and renamed the Natural Law Forum. And this suggests at least two concrete proposals.
By the way, I
It's
will
a
say,
civilization in decline, for sure.
Yes.
no, I'm going to say one of the reasons I love the University of Chicago Law School is the Roman law seminars always oversubscribed.
Oh.
Right?
Is that right?
Yes. Sometimes as many as 100 people sign.
What?
What?
That's because there are so many Italians in the student.
No. They don't want to take my courses in anything else. And I'm not joking about that.
Well, we are out of time. Would you please join me in thanking our panelists?
Great fun by all.
That was great.
I mean, the authors.